Check 3, 4. Check 5, 6.
in international.
Kochmeyer's here.
$12, $16 for 20 minutes.
We can hear you, Commissioner. We're in the room.
We will start
Okay.
momentarily.
Thank you, Judge.
Oh, yeah. Who doesn't like to play bingo?
We will.
Yeah, we have friends that are part of the Elks.
Yeah.
Same thing, and they're bar. Much better.
Makes it go by. All right, it looks like all the commissioners have assembled, and today is October 12th. We will start the commission agenda meeting for the Missouri Public Service Commission. Just to remind those that are on the phone, please mute your phone unless you need to speak so that others can hear the conversation. And today there are 4 tariffs, new orders, and PSC history. And before we get into that, I want to announce order number 4 in today is file number EC 2023-0037 is going to be pulled from agenda this week. And we need to approve the minutes from October 4th agenda. I know those have been distributed in advance. Commissioners, are there any changes, questions, comments about those minutes? All right, then I would make the motion. We go ahead and approve the minutes from the October 4th agenda. All those in favor of that motion, please say aye.
Aye.
All those opposed? All right, that is approved by a vote of 5-0. Heading right on into tariffs and new orders. First up today is file number EW 2021-0267. This is the matter of the establishment of a working case regarding FERC Order 2222 regarding the participation of distributed energy resources aggregators in markets operated by regional transmission organizations and independent system operators. So the commission opened this working file to receive input and determine how the commission should best respond to the changes that are resulting from the implementation of Federal Energy Regulatory Commission, or FERC, their Order 2222, or as some like to call it, 2222, and to review the commission's current practices in the areas affected by that order. So initial comments came in March and April of 2021, and they requested the commission re-examine its order from its 2010 temporary order prohibiting the demand response load reductions of customers being transferred to the wholesale electricity markets directly by retail customers or third-party aggregators of retail customers, or commonly referred to as ARCs. So the temporary order was put in place in 2010. and it became a little more than temporary. So in August 2021, the commission issued an order providing stakeholders an opportunity to comment on what to do and to what extent modifications should be made of the 2010 temporary ban on ARCs to allow demand response load of commercial and industrial customers of the commission regulated utilities to participate in RTO markets. Utility comments requested that the commission leave the 2010 order in place. Other stakeholders, however, asked the commission to modify its 2010 order, noting that the ARCs participating in wholesale markets are regulated by FERC and that both MISO and SPP have regulations in place governing ARCs. These stakeholders also emphasized that ARCs have participated in wholesale markets in other states without comprehensive state-level rule or tariff revisions. So in February of 2022, the commission announced the receipt of a grant from the United States Department of Energy to provide technical assistance to the commission in addressing the state-level regulatory challenge presented by Order 2222. The grant resulted in a report describing how various states have approached demand response aggregators. So back on May of 2023, the commission submitted that report into this docket and sought additional stakeholder comments on the possible modification of the 2010 order for C&I customers. The commission also conducted a workshop of C&I demand response in July. So based off all the information of this docket, this order finds it is appropriate to modify the commission's 2010 order to allow C&I customers of commission-regulated electric utilities with demands of 100 kilowatts or greater to transfer demand response load reductions to RTO markets directly or through third-party ARCs under the specific conditions described in this order. Additionally, a customer with multiple sites under the same corporate ownership may aggregate multiple sites within an electric utility service area to meet the minimum size requirement. So basically, the 2010 order is a win-win scenario. It provides larger commercial and industrial customers the opportunity to participate in wholesale demand response programs, giving them more convenience, control, and choice over their energy consumption. We've heard that somewhere before. Will put downward pressure on the wholesale electric prices, and it cost effectively enhances reliability by helping mitigate grid emergencies during severe weather, both of all which benefit customers. And it also allow the commission and its regulated electric utilities to gain valuable experience with ARCs as FERC moves towards full implementation of Order 2222. And this order also notes that there is no provision which requires C&I customers or ARCs to take advantage of this partial modification. And I would recommend that we approve this order version number 2. Commissioner Coleman.
I support the order.
Great. Commissioner Holzman.
I'm in support of the order.
Commissioner Kolkmeyer.
I support the order.
And Commissioner Hahn.
Thank you, Mr. Chair. Upon joining the commission, this was actually one of the first items that I reviewed, compliments of your advisor, Mr. Chair, of the Berkeley Lab report. But I've spent a little bit more time since then looking at staff's report from 2018 and today's order. Through review of these documents, there's a good argument that ARCs can lead to lower wholesale electricity prices, reduce volatility, help address resource adequacy, among other benefits. I think the order today, which only repeals the ban on the third-party ARCs for large customers, is a measured approach to implementing or allowing this in Missouri. It doesn't impact smaller customers, which I do think would raise significant issues otherwise, like data privacy, and likely, as the utility comments suggested, require a much more extensive rulemaking process. There are a few issues specifically relating to tariff changes. Or utilities may be required to adjust their tariffs to fit this order. Our utilities have operated in neighboring states like Oklahoma, Kansas, Illinois, where there's a much more robust ARC participation. So they should have some familiarity with how that works in those states and be able to adjust their tariffs accordingly. But I want to thank you, Mr. Chair, for delaying the implementation date to 60 days to allow time for the utilities to adjust to this order. So with that, I'll be supporting the order. Thank you, Mr. Chair.
Great. Thank you very much for your comments. All right. All those in favor of supporting that order version number 2, please say aye.
Aye.
All those opposed?
Aye.
That is approved by a vote of 5-0. Next up is file number WR 2023-0344 in the matter of the application of rate increase of Raytown Water Company. So back on September 13th, staff filed the disposition agreement. And on the following day, Raytown filed compliance tariffs with an effective date of October 29th. However, the Office of Public Counsel has requested a hearing. Therefore, the commission will suspend the submitted tariff sheets. Additionally, the commission notes that the rule governing staff-assisted rate case require a commission decision to be effective within 270 days of the filing of Raytown's request for a rate increase. The commission calculates that day, number 270 is January 13th of 2024. So the previously ordered procedural schedule set reply briefs due on December 13th, but because of the time frame involved in submitting the case to the commission finds good cause to waive the 270-day deadline in the rule, but shall make all reasonable efforts to issue an order to be effective as soon as practicable. And I would recommend we approve this order, version number 2. Commissioner Coleman.
I support the order.
Commissioner Holzman.
I support the order.
Commissioner Kochmeyer.
And I'm in support.
Commissioner Hunt.
Also in support.
Great. All those in favor of supporting that order, version number 2, please say oh.
Aye.
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 All those
Aye.
That is approved by a vote of 5-0. Next up, file number EA 2023-0017 in the matter of the application of Grainbelt Express LLC for an amendment to its certificate of convenience and necessity, authorizing it to construct, own, operate, control, manage, and maintain a high voltage direct current transmission line and associated converter station. So back on August 24th of 2022, Grainbelt Express LLC filed an application with the commission to amend its existing certificate of convenience and necessity, or CCN, which was granted to Grainbelt in file number EA 2016-0358. The commission granted intervention to 17 parties, conducted 3 public hearings to receive comments from the general public, and held an evidentiary hearing on June 5th through June 8th. The main objective of the project is to transport clean, low-cost electricity from renewable generation plants to be built in southwestern Kansas, which has a high capacity factor wind and solar resources, to the electricity markets in Missouri and Illinois and other states located within or adjacent to the MISO and PJM grids. The project will be capable of delivering up to 2,500 megawatts of power into the MISO and AECI grids at a delivery point in Missouri, and up to 2,500 megawatts of power into the PJM grid at a delivery point in western Indiana. This extra transmission capacity will both help meet regional energy needs and diversify sources of energy across the region. In its previous report and order on remand, the commission found that there was a need for the original project. In this application, Grainbelt has shown that the need still exists and that there is also a need for the project. There was compelling evidence that expanding the project will lower energy and capacity costs in Missouri by approximately 6.1% over the periods of 2027 to 2066, resulting in over $17.6 billion of savings for Missouri residents. There was also significant evidence that the influx of low-cost, high-capacity factor energy will reduce prices in the MISO markets, resulting in savings across the MISO footprint in the year 2028 of over $1.1 billion. Need is also evident that the project will improve reliability and resiliency of the grid because the project will improve the interconnectivity to multiple regions, helping guard against price spikes and outages such as those experienced by Winter Storm Uri and Elliott. The project is also in the public interest. In my opinion, the project is also in the public interest. It, in addition to the benefits already mentioned of the project, will support the equivalency of 5,757 total construction jobs over 3 years. These jobs are estimated to result in total worker earnings for Missouri of approximately $586 million during the 3-year construction period and approximately $8 million during the operational phase of the amended project. The amended project will also result in significant property tax benefits in the affected counties. So in my view, the broad economic benefits, the increased resiliency and reliability of the grid, the cost savings to Missouri electric customers associated with the project to the entire state of Missouri and beyond outweigh the concerns of the individual landowners. For all the aforementioned reasons, I believe we should approve this order granting Grainbelt's August 24th, 2022 application for a certificate of convenience and necessity subject to the conditions set out in this order. Love to hear the thoughts of the fellow commissioners. Commissioner Coleman.
Thank you, Mr. Chairman. So as we all know, this has been a difficult case that has sparked intense debate and emotion. I am supporting Greenbelt's amended CCN because I'm persuaded by the evidence demonstrating benefits related to grid reliability, access to renewable energy, and economic development. As a lifelong Missourian who grew up amongst farmers, I understand and empathize with the fears and frustrations of the affected landowners. I recognize that for many landowners, this transmission line is an intrusion that they believe will adversely impact both the value and use of their land. Other stakeholders have expressed their concerns about the environmental impacts of this transmission line. And the one concern with which most, if not all parties agree to, is that the transmission lines don't enhance a landscape's aesthetics. I say all of this to acknowledge that the landowners and other stakeholders expressed in testimony and other evidence on the record heartfelt concerns related to the Greenbelt project. I want you to know that your concerns were heard and considered within the confines of the Commission's regulatory authority. I am supporting this amended CCN despite these concerns because the evidence, testimony, conditions agreed to by the company, and those opposed by the Commission have convinced me that the concerns can be mitigated and are reasonably addressed. I recognize that all concerns will not be addressed to everyone's satisfaction, but the evidence presented to the Commission has persuaded me that the benefits I highlighted earlier outweigh the risks. I appreciate every landowner, concerned Missourian, and party in this case for raising the alarms on valid issues, and I hope that Greenbelt Express understands that this CCN comes with a lot of baggage. In addition to the conditions expressly set out in this report and order, I strongly encourage Greenbelt to revisit the concerns raised during the Commission proceedings. I hope the company makes it a priority to do better than they previously done to proactively and responsibly attend to these concerns. This can be a situation in which Greenbelt garners goodwill amongst landowners, or they can provide the groundwork for future opposition. The burden, I think, is on Greenbelt, as I know that landowners, legislators, and the media will be watching closely, as will all of us. Thank you, Mr. Chairman, for allowing me to share my remarks.
Thank you very much for your comments. Commissioner Holzman, your thoughts?
Thank you. This has been a tough one. This is clearly the most difficult case in my mind that I've had in the 3 years we've been here. I think there's a macro view and a micro view of the impacts that this order is going to have. From a macro perspective, it's clear that we need more transmission. We've got congested, clean energy that's bottled up, and it needs to find its way to load. And that would be the case no matter where the location of this was. And that's going to continue to be the case into the future. We're going to have transmission issues continuing for the foreseeable future all over the country. This original line is going to be constructed regardless of the outcome of the vote today. The original Greenbelt Express is going to be approved regardless of the fate of this amendment. So that leaves us to the discussion of what this amendment does. Is this amendment in the best interest of the ratepayers for the state of Missouri? Again, from a macro perspective, it clearly is in the interest of the state of Missouri because it's going to deliver an additional 2,000 megawatts of power. It's going to add an additional converter. It's going to provide more resiliency for storms and natural disasters that we're inevitably going to face. It's bidirectional, so there's a national security implication involved where we could flow power from one side of the line to the other in the event of an emergency. So all of those issues, the amendment itself improves the ratepayers' position on having adopted the underlying amendment or the underlying order. But that still doesn't get us to the micro perspective of if it was your land and I looked at this entire process from the time I walked into the public hearings to the time we had the evidentiary hearings, all the way to this moment of what if it was my property? And in 1978, my grandfather bought 20 acres of a farmland in Cass County, Missouri. And that's been in our family for, since I was 2 years old. And it's important. And there's emotions that go into that land, and aesthetics do matter. And so, for all of those impacted landowners out there, I want to talk to you for a minute and just say that I do understand the anger and the frustration that you've had through this process. And from a perspective of, if it were me and what kind of work could I do as a commissioner, if it was my land that this was going to be affected by, the things that were important to me would be, would I be adequately compensated? Would I be financially adequately compensated for being a partner in this inevitable progress? Would my rights be identified and protected? Would I have any advocacy? Would I have the ability to negotiate on my own behalf? Would I be able to respond to the company if I felt the company had wronged me? There were things that came up in the public hearings that I thought had a tremendous amount of merit. Micrositing. If there was a way to move a line on another part of the property, why wouldn't the company listen to that? So given all of what we heard, we did make quite a few changes and conditions, and I want to go over a couple of them because I think that I'm not under any illusion that any landowner who is going to be impacted by this, anything short of an outright rejection is not going to be good enough for them. There's no condition that we're going to put in here. There's no protection. There's no compensation that is going to have them say, I'm happy or I'm okay with it. But that doesn't mean that we shouldn't and we didn't work as hard as we could within the confines of what the commission allows us to do, the authority that the commission had to try and protect and preserve their compensation and their rights in this process. So what I want to do is I want to introduce a couple of documents that were a part of the case. They are located in the PSC's EFIS. You can find them on the Grain Belt's website. The first one is Schedule K4. And I want the camera to see this so that the landowners can educate themselves and familiarize themselves with these documents, because a lot of what the conditions and suggestions that we made to the company reference back to the 4 documents that I'm getting ready to talk about. So this Schedule K4 is a sample of an easement that was given to us that was between the company and the landowner. So you don't have to start from scratch when you begin those negotiations. This is the Missouri Agriculture Impact Mitigation Protocol. This is the Missouri Landowner Protocol. And this is the Grain Belt Code of Conduct. Now, all 4 of these documents were previously agreed to in the previous order by the company and have already been established under the original line. All of these documents are designed to lay out and spell out the interaction between the company and the landowners as they go through this process of negotiation on an easement or the potential for condemnation if it gets to that. House Bill 2005 was passed in the last legislative session that also lays out statutory requirements in dealing with condemnation. My hope is that all of the landowners educate themselves to all of the communications that are available to them so that they are equipped with the knowledge necessary to have a fruitful negotiation. Now, some of the things that we did in this order to help support that was how this worked was a month or so ago, maybe 6 weeks ago, we all talked about the concerns that we had. Those concerns were vetted by our staff, they were vetted by our legal department, and they were made recommendations on what we thought we could do within the confines of the power that the commission has. We don't have the power as a court. We don't have the ability to compel a private company to do certain things that we would like to or potentially would discuss, because that's not statutory authority that we have. But one of the one of the concerns that was laid out was dealing with direct compensation. So in this order, as a condition of the CCN, the company is directed to offer either a 150% outright one-time proposal or a 110% plus structure compensation for the line for the landowners. And this would be a fair market value option, and the landowners would receive crop or damage payments. And that is also laid out in the protocols. The second thing that we did was we talked a great deal about third-party vendors. And we know that the company is most likely going to have an opportunity to run fiber or other communication lines on the poles or different attachments that they could enter into agreements with third-party service vendors that could provide fiber or broadband to other folks. That may not necessarily be covered in the easement, but what this order suggests is that the 150% fair market value or the 110, whichever option the landowner chooses, those are not caps or restrictions on additional negotiations that the landowners can engage in with the company in their easement that would represent a value for what those third-party service negotiations could have. Now, how, to the extent that happens is going to be between the company and the landowners, but it's in this order for it to be acknowledged that that is not a cap that the company can say would preclude them or prohibit them from having negotiations dealing with third-party services. So that is in this order. We included as a condition that the company inform the landowners of the Office of the Ombudsman for property rights. This ombudsman can provide guidance, not legal advice, but guidance to individuals seeking information regarding condemnation process and procedures. The office is a creature of statute, section 523.277, and each landowner will be notified of this office ability to guide them as a condition of this order by the company. We've talked about more clarity in this order. We make multiple suggestions as to where the landowners can find some of this information, and we title that in the protocols, which is why I introduced these documents. And then we've also laid out in this order how a complaint, if the company is not following through with this order and the conditions of this order, then landowners are capable of filing a complaint with the commission. Now, I've stated earlier, the commission is not a court, but we do have the ability to impose penalties upon grain belt, and those penalties could potentially be from 100 to 2,000 per day for noncompliance pursuant to section 386.570, and those funds would be payable to the public school fund. So that may not necessarily address your individual specific complaint, but it is an ability of the commission to at least have the company be responsive to some of the issues that we could potentially see in the future. We required a number of reporting on notice. So if the company does not provide a 72-hour notice to the landowner before they enter the property, then they will have to explain to the commission in a report why that notice was not provided. We ask for reports dealing with employment, making sure that the job and economic impact, that the jobs, did we got claims that they were going to be Missourians? Were they Missourians? Now, again, all these reports are going to be retrospective, but they will be beneficial for us to understand what the company promised and what was fulfilled. And finally, on the micrositing, this one, I would like to have seen a little bit stronger language, but essentially in the condemnation process, the company is required to provide in writing when a landowner asks to have a line co-located or moved onto a portion of a parcel, as long as it's the same parcel, and the company is required in writing to provide them either affirmation or a reason why they were not granted that request. Our suggestion to the company is that they provide that benefit in non-condemnation processes, that everyone have the ability to get a written response from the company why they weren't able to co-locate. We did our best to try and come up with ways that would protect the landowners in this process. We want the landowners and the company to be partners. We want the landowners to be made whole and to be compensated justly. And we want the company to be responsive when the landowner feels that that is not being taken care of. But I also think that the company is engaged in a project that will be a benefit to Missouri. It'll be a benefit to the Missouri ratepayers. It'll be a benefit to our nation. And for those reasons, I'm going to support this order.
Great, thank you, Commissioner, for detailing all those the details that I did not go over, and giving the public a little more insight into some of the landowner.
I'm sorry to be so
research.
long-winded.
No, you're not at all. This is a lot of information. This has been going on for 10 years or 8 years, a long time and stuff. And so the more information you can give people of what's in here, the better. So I appreciate that information being shared. Commissioner Kolkmeyer.
Thank you, Mr. Chairman. I think all of us have dealt with grain belt one way or the other. Most of the time we have been in Jeff City. Most of us over at the Capitol. I don't believe I was on utilities the year that this was voted out. I remember talking about it, but I don't remember being on the utilities that particular session. But what I do remember is that the ag groups and the landowners were concerned that no electricity was being dropped off in Missouri, that this was just a pass-through line going coast to coast across Missouri, and Missouri was not benefiting whatsoever. And that was a valid, very, very valid point, that this is just a cross-country line. Coming back, that got approved. Here again, I don't believe I was part of that. But now we come back, and now the Grain Belt has agreed to put up to 50% of the capacity of that line, dropping it into Missouri, one way or the other. That is a huge benefit for Missouri. Right now, there are companies that are wanting this electricity that's going to be very beneficial. The economic impact that this line can do is huge. However, I will say this. One of the things that we heard loud and clear from the ag groups as well as the landowners is how they weren't being treated very well. Some of the negotiations, some of the landowners felt like they had been strong-armed here. That did not go, unnoticed, and we heard those complaints. We took those to heart, and I think and hope that the company will listen to those and take our advice in trying to work with these landowners and mitigate some of these problems going forward. And also their customer complaint line. A lot of landowners and people were not happy with that as well. So I hope they do some improvement there on that as well. I'm supporting a lot of this because of some of the safeguards, as Commissioner Holzman talked about, is some of the safeguards, and this is coming because we did hear the complaints from the landowners. So I think this is a very good compromise in all the way around of what we as the commission has the authority to do. So with that, Mr. Chairman, I'll be supporting this order.
Great. Thank you very much, Commissioner, for your comments. Commissioner Hahn.
Thank you, Mr. Chair. I spoke on this at length previously, so I think today my comments will be hopefully shorter. When I spoke on it last time, I did walk through a full tartan analysis of how I thought I might arrive at a conclusion today for an order, but I wasn't completely sure. So in revisiting my tartan analysis, I'm not going to repeat myself here, but I did have a concern on at least 3 of the 5 criteria, specifically relating to need, economic feasibility, and public interest. You know, the original line was going to drop 500 megawatts of power here in Missouri, 300 megawatts of which is still not contracted for. Now with that, you know, fairly short notice, we are now dropping 2,500 megawatts of power here. Now with 20, that would make a significant amount that would still not be contracted for. I don't exactly know 100% why that change was made and why more power here, though I do think it is in line with the concerns of the General Assembly wanting additional power to be brought to Missouri from the line. On economic feasibility, I was previously concerned, still am, that there was no evidence presented by Grainbelt on how phasing is economically feasible, as previously the commission decided that selling into PJM is what justified the economic feasibility. And in this case, they presented no evidence on how only constructing phase 1 or phase 2 is economically feasible. And then there's public interest, which gets me to a list of concerns. Relating to the conditions and public interest in this specific order, I do think this version of the order is significantly improved over the first version of the order that I saw. I really want to thank the other commissioners for making this order better for landowners, offering compensation options of the 110% plus structure payments or the 150% of fair market value. Increasing notice reporting requirements for 72 hours, and putting reporting requirements around notice and economic development criteria, etc. I want this line to benefit everyone to the maximum extent practicable, but I don't think that this order goes far enough. I do think there could be additional notice for approaching the property for the first time. This project or this application has gone on in the state for almost a decade. And currently the landowner protocols only require that the company give the landowner 24-hour notice for approaching the property for the first time. If I were to put myself in the shoes of the landowner, I don't think I would feel comforted in the fact that they've known that the line's coming for a decade and they give me 24-hour notice before they're coming on my property. Also, with regard to crop compensation, currently in the KC4 document, there's a provision on crop compensation that allows, if there is damage to a landowner's crops, Grainbelt will repair or pay for that damage at Grainbelt's option. There actually has to be a conflict with the landowner protocols in order for the landowner to get any deference in how that may be construed to favor the landowner. But the plain reading of the easement agreement is that it's at Grainbelt's option. I think that that easement agreement should be modified to break at the landowner's option, as they know best how to take care of their land. Also, there's a provision in the KC4 document relating to the telecommunications easement. I think that Greenbelt's intention is to sell or lease currently probably unlit fiber to a third party for them to distribute to, for rural broadband development purposes. And the landowners would not be compensated for the additional use of this transmission line for that purpose. Greenbelt could offer to compensate or be required to compensate the landowners for that use. Greenbelt did not offer these items, though I would encourage them to do so. Regarding Greenbelt and their approach to landowners, as being my first case on the commission, I learned a lot of things and still learning, but I was really taken back by Greenbelt's approach to the commission. Greenbelt's approach to the commission seemed aberrant, and their responses were evasive. It was very difficult to get a clear response. It was clear that the company was very calculated in what it was saying to release the minimal amount of information. And I can imagine if that's the same way they approach the landowners, that's why the landowners are so upset with this particular company. And that's, the concerns that Commissioner Kolkmeyer raised about the company not being responsive to landowner concerns. Even Commissioner Holzman in the hearing asked Mr. Chandler about micrositing. Has any landowner requested micrositing, and have you accommodated the landowner? Yes, we have, but couldn't name a single example of where that had happened. My third concern is really on cost allocation. This is significantly concerning for ratepayers. Greenbelt and Invenergy did file a formal complaint with FERC against MISO to require the RTOs to pay for this, the benefits of this and other merchant HVDC projects. I would be concerned that if this project is approved, or even in the initial line, that Invenergy may construct and operate the line, but eventually shift the cost to the RTOs and Missouri utilities for ratepayers to absorb. It seems as though, in this case, I don't disagree that we absolutely need transmission, but with this case, in this particular case, and the conditions that were not offered by Greenbelt and the approach that they have had with landowners, I am very concerned about this project moving forward. If I had a message to the General Assembly, I would really look at the statute regarding good faith negotiations being modified specifically for projects like this, regarding crop compensation, third-party easement compensation, and notice for these merchant line projects. Perhaps this is something that could be revisited in the future General Assemblies. So with all of that, I feel like I've said enough between last time and today. So at conclusion, I will not be supporting the order today. Thank you, Mr. Chair.
Great. Thank you, Commissioner, for your comments. Okay, I would make a motion that we go ahead and approve this order, version number 4. All those in favor of that motion, please say aye.
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 All those opposed?
Aye.
That is approved by a vote of 4-1. And next up is file number EC 2023-0334. This is Kevin Kajeski, complainant versus Evergy Missouri West Incorporated, DBA Evergy Missouri West, respondent. So back on March 30th, Kevin Kajeski filed a formal complaint with the commission against Evergy Missouri West. On May 1st, Evergy Missouri West filed its answer, its affirmative defenses, and motion to dismiss. On June 15th, the staff of the commission filed its investigative staff recommendation, and the commission set a procedural schedule conference for September 22nd. Mr. Kajeski did not appear for the procedural conference and did not contact the commission to request a continuance of the conference. Because he failed to appear for the scheduled procedural conference and failed to comply with the commission order to show good cause for his failure to appear, the order will dismiss his complaint as provided by commission rules. And I recommend we approve this order, version number 1. Commissioner Coleman.
I support the order.
Commissioner Holzman.
I support the order.
Commissioner Kolkmeyer.
I support the order.
Commissioner Hahn.
Also in support.
Great. All those in favor of supporting that order, version number 1, please say aye.
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 That is approved by a vote of 5-0. All right, that's all the filing, all the tariffs and new orders we have today. We have no case discussion. So next up, we have a guest with us, our new Deputy Director of Staff Council, Mr. Travis Pringle. Why don't you come on up here and join us? Oh, I know. Well, for those that don't know, he recently was promoted to this position, and so we decided we would reward him with the ability to give us some PSC history and kind of educate us a little bit. So first off, congratulations, and we're excited for what you have for us today.
Oh yeah, thank you again, Chairman. So my history moment is actually about that photo outside the elevators on this floor, the photo of the staff from 1915, specifically the boy sitting on the floor named Joe Edwards. I've been wanting to know what was his job here. So actually I called the state archives, and shout out to them. It took them 5 minutes to find everything I needed. They were pretty quick. They pointed me to the blue book, the first time the commission ever appeared in a blue book, which was 1913, the year we were founded. It was kind of interesting looking at that. At the 1913 posting, we only had a half a page in the manual, and it was the 5 commissioners, the general counsel, and then 22 employees of staff. They were almost entirely clerical, and there was only one telecommunications expert, one expert for both electric, light, and water, 3 engineers, and 2 accountants, and that was staff. Joe Edwards, though, he was still not part of staff in 1913, so we looked at the 1915 Blue Book. At that point, staff had expanded from 22 employees to 39, and we actually had departments too. We had a general office with 10 employees, an engineering department that now had 10 employees, a department of statistics and accountants, which had 8 employees, which was up from 2 in 1913, the railroad rate department, which had 3 employees, electric, light, water, and gas, all under one department that had 2 employees, a telephone and telegraph department that had 2 employees, and the official commission reporters, which that was 4 employees total. Mr. Edwards, he was part of the general office of those 10 employees, and he was the commission's messenger boy. We didn't have telephones there, really just the telegraph, and he was running messages throughout the commission office and throughout Jefferson City on behalf of the commission. And for that, he was compensated $240 a year in salary.
That's fascinating.
And that's it. Mr. J.L. Edwards was what he was named in the manual.
J.L. Edwards, the messenger boy.
The messenger boy.
Awesome. I have this sinking feeling that your new nickname is going to be the messenger.
His legacy alive.
Well, the only thing or is it hopefully Mr. Edwards was a better chili cook than I know you're crushing defeat of the chili cook-off the other day. So
I gotta believe he'd be better than me.
no one is ever going to apply for a promotion again here. This was nice and stuff. So you're a great sport. Thank you. Congratulations on the promotion. Thank you for I mean, I wouldn't even have thought about researching that boy and stuff. So Mr. Edwards, the messenger boy.
The messenger boy.
That's excellent. Just Commissioner, do you have any comment or questions for our new deputy staff council?
Thank you. That was an excellent
let him get
historical report.
Yeah, thank you.
And that was
Absolutely, yes.
the early 1900s for a kid.
Yeah, it was
Big money.
That was pretty good money for him.
Yeah.
Prior to labor laws.
Yes.
Thank you very much.
Thank you, commissioners.
Well,
Thank you, sir.
Great job. Great, wonderful. Appreciate it. You hit it out of the park. So I'm hearing rumblings. Some people have some stuff already, keyed up and stuff. So so apparently people are already starting to do PSC history research just in case they get called. So we'll have to see what the future will hold for us. So next up, we got scheduling. Wednesday, October 18th, we have agenda at 12:30 p.m. On Wednesday, October 25th, we have agenda at 10:15 a.m. Thursday, October 26th, we have evidentiary hearing in WC 2023-0142 This is Goad versus Missouri American Water Company. That will be in room 310 at 9 a.m. at Commission's headquarters. Wednesday, November 1st, agenda at 10:15 a.m. And Wednesday, November 8th, agenda at 10:15. An evidentiary hearing that same day in case WC 2023-0273. That is Nealon versus Missouri American Water Company. That is in room 310 at 9 a.m. At the Commission's headquarters. And that is all I have for scheduling. Commissioners, anything else before the good of the order?
Go Chiefs.
Chiefs? Great. All right, that is all.
Absolutely.
All the business stands before it. We are now adjourned.
Thank
Thank
you,
you,
Mr. Chair.
Commissioners.
Thank you, Mr. Chairman.
Thank you, Mr. Chair.
Mr. Chairman, today's the home opener for the St. Louis Blues. A real